In light of the lawsuit that has not yet been settled, the biggest news will make XRP holders excited for an even bigger price hike for XRP. And this is because the judge gives SEC a favor. With this, stay tuned to this video to learn more about this. Welcome to Crypto Live. Don't forget to like this video and subscribe to our channel to stay updated on our upcoming videos about cryptocurrencies. Considering ETH as security, former SEC Director William Hinman's famous speech in 2018 causing ETH's price to soar is at the center of the debate. Meanwhile, it has recently been discovered by Ripple's legal team that descriptions found in the SEC's privilege log could be relevant in this matter. This email chain in particular, concerning discussions with a third party whom defendants understand received guidance from the SEC to analyze its digital assets under the framework outlined in Director William Hinman's June 14, 2018 speech. At the time, Attorney Jeremy Hogan observed that the SEC present contradictory statements by saying the SEC sent an email to a third party telling them to analyze a digital asset using the factor in the Hinman speech, which speech was just his personal opinion. I understand how it's the SEC that needs clarity. And in Hinman's speech, the SEC's official policy could be proven as opposed to a mere opinion. Then, in the lawsuit, this has been an important issue. In addition, as long as the judge confirms that the SEC for so long has maintained that Hinman's speech was simply his personal opinion, while nonetheless advising clients based on that speech, the SEC will likely be in a bad position throughout the lawsuit. As for breaking news, it was recently announced that Judge Sarah Netburn has ruled in favor of Ripple's request and will be reviewing the documents and emails on camera. Defendant's request is granted. The SEC shall submit the two documents related to the SEC's meetings with law firms and the email chain for in-camera review, along with a submission explaining its privilege assertions for each of those documents, no later than October 15, 2021. The SEC shall file a redacted version of its submission on the public docket. Defendant's response is due no later than October 22, 2021, so ordered. On the SEC's deliberative privilege process issue, the date when the judge will conclude the review and rule is unknown. However, Ripple has submitted a revised response. Judge Netburn, who is ruling on the Ripple vs. SEC case, ruled in favor of the SEC, and it is one of the few instances where emotions have worked against Ripple in the SEC. So in this video, I will talk about what Judge Netburn told Ripple about what they need to do to produce, and what it means for Ripple in this case. But for Ripple XRP holders, this was a green day recently. So first, here is a quick look at some of the new all-time highs that occurred, what Bitcoin did, what XRP did, and what the next resistance level was for XRP, where it might go, and if it did break that level. Meanwhile, the $1 trillion infrastructure bill in the United States is just about ready to pass and is on Joe Biden's desk awaiting signature. There has been a lot of controversy over crypto tax reporting provisions, so in this video, I will explain what those would do and why some find it so troubling. First, I want to talk about how much of a green day today is. The increase is a carryover from when Bitcoin started its rise last November 7th, when it went from about $62,000 to $65,000 in a matter of about 30 minutes. Further, oil coins were taken along with the climb. Basically, Monday morning, November 18th, it kept doing what it had been doing. Last November 11th at 1931 UTC, the price of XRP was about $1.20. But seeing some quick analysis of technical indicators earlier today that indicated it was close to the next resistance level of $1.38 to $1.40. And if it were to surpass, $1.80 to $2 could be the next target, which could happen sooner than most people think. No matter what has happened to Ripple in the SEC case just now, move over Cardano. The cryptocurrency that's now one of the most controversial as to what exactly it is going to do on this bull run, since they are out, a lot of people are saying it's virtually dead in the water. Then some say it'll probably be 10 or 20 times faster than that, and they're going to do it right away. In any case, it indeed started climbing after weeks upon weeks of inactivity, moving from just over $2 just the other day to now above $2.10. Ether continues to set new records, now sitting just above $4,700, while Solana is keeping a close eye on its all-time high at $247. Cryptocurrency market capitalization is also at an all-time high of $2.86 trillion. As everyone is gaining so much in the crypto market currently, it seemed only fitting to discuss tax reporting. As of right now, Joe Biden is awaiting Congress's approval of its infrastructure bill before signing it into law. Also, including in this bill is a provision specifically addressing a stirback in the summer that the House and Senate debated it and tried to get it either removed from the IRS system or changed so that the crypto industry wouldn't be burdened by it as much. But none of that didn't happen. Despite repeated congressional attempts, nothing was accomplished with this provision. What does this provision deal with? Congress just passed the final bill, and there were two opposing views. Two things are primarily causing concern among people. The first being the broad language used in the tax code. In other words, it now imposes reporting requirements for people they consider brokers. Moreover, the language used by them to determine who is a broker is extremely broad, which was a basis for many of the arguments. Because it includes people like minors and other third parties who do not facilitate transactions in any way. However, it soon puts them in the crosshairs. Then, in terms of reporting the users or people who are now considered as brokers, and then in terms of reporting to the IRS as to who is doing the trading, and even sometimes, the IRS isn't even able to check in on everything. Fortunately, the other part of it that opened people's ears was the Tax Code 6501, which is a 3-year-old code that was specifically written to address in-person transactions over $10,000. In this new infrastructure bill, the reporting requirement applies to cryptocurrencies. Therefore, any transaction exceeding $10,000 must be reported by the receiver of that money to the sender so that the sender can verify the transaction. Meanwhile, in the cryptocurrency world, this is a bit tricky since many people want to remain anonymous, or at the very least, generate information through sources that are very difficult to get information about, like buying and selling NFTs, for example. In the current situation, it is a criminal offense to fail to notify the IRS that you received money from a digital asset transaction over $10,000. As a result, the Treasury Department has announced they will issue guidance and explain how to interpret the law in a way that would be applicable. Of all the people, the government probably has the least knowledge of cryptocurrency generally, so it is kind of interesting. Moreover, a new tax law customized for the crypto world would be like the CDC issuing dietary guidelines. It won't be pretty. The Ripple story, however, is that Judge Netburn did not rule in Ripple's favor. It is a rare circumstance because, so far, Judge Netburn has decided most motions in Ripple's favor. Further, it was only one, a week-long extension of time, that went in the favor of the SEC. Further, you're going to pay property, and among U.S. Securities and Exchange Commission, what it has been asked to produce. Several months ago, the SEC said they knew Ripple had recorded their meetings, and they discovered through depositions that Ripple recorded many of their employee meetings. That's thousands and thousands of hours of recorded meetings. So how on earth are we supposed to go through that? So now do we take that pertinent material? The judge ruled in favor of the SEC, and you must turn over the documents. I would advise you to use speech-to-text software similar to voicemail, apply it to your recorded meetings, then convert them into text, or simply do keyword searches to find what you want. Then, according to SHIB, the SEC and Ripple will meet to determine if any specific time frames are of greater interest to the SEC. As a result, Ripple will be able to assess the meetings that took place in a specific time frame. With this, Ripple is encouraged to start conducting these searches right away. In addition, if you're following the case, you are wondering why the SEC hasn't turned over the documents, particularly the ones the SEC was supposed to turn over without delay to Judge Netburn. And this has not happened yet, based on what I saw last time. So why is this important? In terms of the SEC suing Ripple for marketing practices, it sounds like it's probably on the pretty weak ground since XRP is classified as a security. That is why they are really suing it for marketing practices, not for being actual security. It's simply a case of grasping at straws to claim that Ripple sold XRP as a security, regardless of whether XRP was security or utility. XRP holders know well that it is a utility, since it is a cryptocurrency. That's all for this video about crypto, and thank you for watching. If you would like to receive updates on the crypto market, make sure you click the subscribe and bell button.